All right, and welcome back. Attorney Steve Vondran here. Welcome to another exciting episode of Settlement Terms. Okay. All right, so this is going over some of the common settlement terms you might find in a settlement agreement, okay? This one is called the non-disparagement clause. Oftentimes you will see this in a settlement agreement where you have two parties that were really head to head and really upset with each other, like partnership disputes or something like that. Or sometimes big companies will be demanding non-disparagement clause. Like, I'm not going to go into it, but just Fortune 500 companies oftentimes want this non-disparagement. They don't want people talking on the internet. They don't want people blabbing about their settlements. So let's take a look at this. This is one I drafted. This is not legal advice. This is just a simple one that I drafted and what it might look like and what it means. So here we have the parties and their respective employees, agents, representatives, or counsel, and anyone else acting on their respective behalves hereby agree not to directly or indirectly, and neither orally or in writing, make any negative or disparaging statement, remark, suggestion, or post of any kind against the other party, which in any manner is objectively offensive, casting a false light, ridiculing, defaming, or otherwise speaking ill of the other party or its attorneys, business affairs, business practices or policies, standards, or attacking the other's reputation. So that's just a regular clause that tries to cover all the different types of communications that could be made, oral, in writing, whether it's done by you or you had some friend do it. Let's go to the next paragraph. This prohibition shall apply indefinitely. That means forever, from the date of the settlement agreement, to all forms of media and other modes and channels of communication, whether offline or online. That covers a lot of things. Example, in any form on the internet, including social media websites, including but not limited to Twitter, Facebook, Instagram, YouTube, and other internet platforms, and including but not limited to any statements made to any persons who work for the media or persons and entities engaged in radio, television, or internet broadcasting, including but not limited to blogging, podcasting, and other forms of digital communication. So there it is. You're trying to cover all forms of media, online and off. That's pretty broad. The point of the matter here is to prevent the other party from even thinking about running around and saying something negative on the Facebook, like, these guys are a bunch of turds and, they forced me into a settlement. So they're trying to prevent these disparaging statements. Or my partner, I learned during the course of our dispute that he cheated on his wife. What a bad guy, that kind of thing. So you're trying to stop this from happening. And finally, what happens? Any violation of this section will constitute a breach of the settlement agreement and will subject the other to monetary damages for breach of contract, including reasonable attorney fees. The parties agree that any such lawsuit shall be filed. Insert your state. I have California. And agree that California law will apply and that both parties consent to the jurisdiction of the court. So there you're just kind of laying it out. If the other party dares to open their mouth and in any way disparage in a way that could be deemed objectively offensive, there you have it. You have a clause and there's a breach. And now another thing you could do, if you watched my video on liquidated damages clause, you could put in there that, that the damages are tough to calculate. And because of that, if either party breaches, it's a $50,000 liquidated damages provision. You could do something like that. I just like to hold them in breach, but, some people may disagree on that. At any rate, you often see this clause along with the confidentiality clause. They're kind of one and the same, but whenever you're dealing with like Fortune 500 firms, them or their counsel usually are going to require both a confidentiality, which is basically just saying you got to keep it confidential, and a non-disparagement. So to me, they're kind of the same, but we often see those hand in hand, okay? And we'll be talking about those in another video down the line here, but that's about it. If you have any questions dealing with settlement or litigation, we are civil litigation attorneys, business, real estate, intellectual property. That's all for today. I hope you enjoyed this quick little video. If you liked it, give us a thumbs up so we can keep these videos coming your way. And don't forget to subscribe. Okay, have a great day. Attorney Steve out.